Good morning.
Good morning.
Any further comment or argument regarding the witness from yesterday, the last, Mrs. Smith?
Yes,
Ms.
Your
Smith's
Honor.
testimony, yes.
Yes, Your Honor. We did get a transcript, overnight transcript of her testimony. It's very rough, but on recross, if you will, at page 90, I asked her, have you ever seen this rain jacket before? And the rain jacket, I'd put a photograph into evidence, Defense Exhibit 87, and she says no. And then I said, did Alec Murdaugh have that rain jacket with him when he came to Ms. Libby's home on the morning, I believe, a few days after the funeral? She says no. And then I asked her, have you ever been in this closet before? Pointing to the state's exhibit, where they show something folded up. She says, no, I haven't. And then I asked her, so you don't know what that is folded up there, do you? And she says, correct. And then I asked her, if what's in that closet is this rain jacket, you've never seen Alec Murdaugh with this garment before, have you? And she says, no, I haven't. And that's the testimony and that's on page 90 of the rough transcript that we got last night. Well, this morning we got it, Your Honor.
All right. From the state.
Your Honor, again, it is fairly rough to try to read some of this, but as I would go back and point to page 65, where the witness was asked to describe it. Again, she talked about observing Alec coming to the house at an unusual time, a few days after the murders, carrying a bundled up blue vinyl item, and then she was shown a picture with it in that closet where it was recovered, and she said, did you see a blue object in the center? Yes. Does it appear to look like the object you've described? Yes. You're saying yes. Is it the blue vinyl? This appears to be the same thing you saw the defendant holding. It looks so, yes. And of course, then you had subsequent testimony from the crime scene investigator about recovering that very item that proved to be the raincoat, which of course, if you hold it out, is very, very large and very much like a tarp. So I think many of these issues that the defense is raising are issues for jury argument and go to weight, not admissibility.
The witness testified on direct examination that the item in evidence appeared to be what Mr. Murdaugh brought into the house that night. She said he was carrying something, it was in his arms. She said it was blue something, that it looked something like a tarp, blue something, but she did not know what it was. It wasn't opened up, and she could not clearly identify the item either as a tarp, as was shown by Mr. Griffin, or as a raincoat. She testified that the item presented was consistent in appearance with what Mr. Murdaugh brought into the home that night and what was shown in the photograph that was taken. Certainly Mr. Griffin did I would say an effective job in cross-examination in raising questions as to the credibility of the witness. That is the exact job that a jury has to do, that is weigh the credibility of the witness and to determine whether the testimony was consistent on the one hand or inconsistent on the other hand. And this witness's testimony was consistent on the one hand and inconsistent on the other hand, but that does not make the testimony inadmissible. It doesn't render the evidence inadmissible. Whether evidence can be made relevant and admissible through inference. The inferences can be drawn from the evidence. It is circumstantial evidence that is a part of this case, which suggests a fact by implication or inference. It could be the appearance of the scene of a crime, testimony that suggests a link to the crime, and if it can, facts can be proven through inference. The facts and circumstances through which the witness testified on direct and cross-examination and taking the testimony as a whole. The item is in evidence. I find that it is relevant in that it creates, through inference, facts that are in dispute in this case. And I deny the motion to strike her testimony, if that's what the motion is. I deny the motion to declare her testimony as being irrelevant. And the latest motion was that it's prejudicial or the results of an examination of the item is prejudicial. Of course, we haven't had that testimony, but we have an item in evidence. We have many items in evidence. We have, items are being placed in evidence as, what number are we up to now? 400, 500?
400, Your Honor.
400 items of evidence. Witnesses have been questioned as to whether they walked the side of the roadway to see whether anything was along the roadway other than a cell phone. Witnesses have been questioned as to whether or not they looked down the drain pipe or of a tub or shower, or just any number of questions been posed with the witness to the witnesses as it relates to discovery of evidence. This evidence was obtained through a search warrant. It is in evidence and it's there for the jury's consideration. Certainly, once an item is in evidence, and as long as a chain of custody has been established, there can be testimony as to what it is or of what significance is it. And that's the stage we are here in these proceedings. And I deny the motion to strike it, to find it for relevance purposes or because it creates or presents evidence favorable to the state, which automatically means it would be prejudicial to the defendant. Yes, sir.
Your Honor, just to clarify, the motion that the defense made late yesterday afternoon was in advance of Megan Fletcher, SLED agent Megan Fletcher's testimony that there's GSR on the blue rain jacket. And so the motion was to prevent her from testifying as to the GSR, the testing of the rain jacket, under 403. I understand the court's ruling. I don't think they're going to call Ms. Fletcher first, but when she does take the stand, we will, for the record, renew the objection. And
That's just the point. You say you object under 403, claiming it's more prejudicial than probative. And that's a fact-finding issue. That's an issue to be weighed not by me, but by the fact finder. I am to determine whether it's more prejudicial than probative. It's relevant. It's apparently important enough that the state seeks to use it. All evidence adverse to the defendant can be considered to be prejudicial, but I do not find where the any prejudice is substantially outweighs its probative value. So I deny that motion. I certainly respect your objection. The witness sort of all over the place with her testimony and appeared to be confused. I'm not sure she obviously was not of the same level of unable to articulate her thoughts through her emotions and through this setting of being examined and cross-examined in this case. But the testimony taken as a whole shows that she identified the item as being consistent with what she thought the defendant brought in. She said he had something in it. It was important enough for her to contact someone about it, and that landed her here on the witness stand, among other things, other reasons. But everything is noted and protected for the record.
Thank you, Your Honor.
Yes, sir. Ready for the jury.
Ready to proceed, Your Honor.
Right. Regarding juror numbers, spoke with, so I guess I've now said him, spoke with that juror briefly this morning, and he's going to stay with us. He's made some arrangements, he thinks, with his job, and he's going to stay with us. We have another juror, however, juror number 548, who made contact with the court and says that he's at the emergency room this morning. We don't know what his situation is. He is an alternate juror, and we'll need to proceed without him. Juror number 548. As time passes, attrition kicks in. And we've done well thus far. This will be the first juror who will be excused. He's at the emergency room. We don't know how long he'll be there. We're not going to delay the trial until we find out. So we'll proceed without that juror. Yes, sir.
Stay, Your Honor.
All right. You bring the jury.